technology and professional IT services company with offices located in USA, Mexico, and India. And Cogent IBS I'll just give a small intro, okay? And Cogent IBS is a SAP partner specializing in providing SAP project consulting services, product development, RPA solutions, and staff augmentation services. And Cogent has been hiring talents across the globe by extending many types of immigration visa routes such as H1B, TN, and E3, L1 visa categories, and green card as well. We work closely with attorneys and we share good connection with our attorney here, Joseph Kalabat Associates. Joseph Kalabat Associates are based in Michigan and they are serving clients' business and professional needs and also specializes in employment-based immigration as well as family-based immigration matters and corporate law. Joseph Kalabat Associates continues to provide their clients a full spectrum of immigration services. And we're happy to share their approach on complex immigration issues and legal matters are outstanding. And here in this call with us, Joseph Kalabat is here and our attorneys, Michelle and Scarlett are here. Small intro about Michelle. Michelle Kashmika has received her Bachelor's of Art degree in English Language and Literature from Wayne State University and her Juris Doctorate from University of Detroit, where she has awarded Dean Scholarship and Excellence. Michelle is a member of State Bar of Michigan and admitted to practice before United States District Court for the Eastern District of Michigan. And along with Michelle, Scarlett is also in this call. And Scarlett received her Bachelor of Social Work from Michigan State University and Juris Doctorate in Law from the University of Detroit. Scarlett is an active member in Michigan Bar Association. And today's topic is going to be about change of status. That is what we are going to talk about it. Over to Joseph and Michelle and Scarlett now. Thanks a lot.
Thank you, Isha. Thanks, Eric. Well, basically, the change of status only applies to individuals that are in the United States. So I know a lot of people have questions about that, but in order to process the change of status, it all depends on your visa category that you hold in the USA. There are certain benefits with certain change of status applications versus others, but primarily when we talk about change of status, it's the non-immigrant change of status, which is typically when someone comes in on a visa, such as possibly a visitor visa and wants to change it to maybe a student visa or an H1B visa, or maybe someone's on an H1 visa and then wants to change it to a dependent visa, such as an H4 visa, or maybe go back to study and change to an F1 visa. But one of the main requirements of changing status in the United States is that the person has to be maintaining that status. For instance, with respect to H1Bs, if you're maintaining your status on an H1, you can always change to a different category as long as you're maintaining that status, and within 60 days of possibly being terminated on an H1, you're able to go through and still file an application to change over to maybe a student visa, maybe an F1 visa, if you qualify for an E3 visa, which is for Australians. There's different things that you can go through and do, but typically, in order to do a change of status, you have to be in status at the time, maintaining your visa conditions, depending on which visa you're on. And at times with certain categories, Homeland Security will give you an extra 60 days to go through and make a change at that point in time. Michelle, do you have anything to add, or you want to go through some of the slides?
Sure. Thank you, Joe. And thank you, Usha, for the nice introduction. So I don't know why, I think I was just trying to get it to load, but I do have on the slideshow the About Cogent section, also about Joseph Kalabat and Associates. We also had an introduction slide, and the agenda for today was an introduction, a review of the last session, how to change status, which Joe just mentioned, and questions and answers. So just an overview of the last discussion. We talked about going to and from the H1B. Just as a review, the H1B is a quota that has to be, you have to meet that cap, it's called, by being registered by a sponsoring employer. Once you are registered, you have another hurdle to overcome by being selected. only when you're selected can you obtain the ability to potentially get on H1B. So with your selection notice, that H1B sponsoring employer, such as Cogent, will file an H1B petition for you pursuant to what your current position is. If you're in the United States on a different visa, as Joe mentioned, we would file you as a change of status because you're changing from one visa to another and you're already in the United States. If you're abroad, we file you as a consular notification. You'll go to some embassy in India or consulate in India that you reveal to us. We put it on your forms and say it's Hyderabad. You'll go to Hyderabad, get stamped with your H1B visa and enter the United States on that visa stamped.
And the one thing, Michelle, I don't mean to interrupt, but I wasn't on the last call because I had a conflict, but Usha, I also wanted to go through and let you know that due to certain issues that have taken place, there most likely will be a second and a third round of lottery this year.
Okay.
Last year, there was only one round and everything was used up, but due to certain issues that have come to light with certain companies receiving notice of intent to revokes and denies for their last year's application, there's going to be, in my opinion, significantly more available visas for the second round and also possibly a third round of selection. So, a lot of people on the call may have applied for the lottery. They may not have been selected because there were approximately 800,000 registrations that were received. But don't lose hope because most likely what's going to happen is the second and third round. So people are going to get another opportunity to possibly be selected.
Oh, that's great to know, Joseph. It's a good news for most of them who were in the call and then not selected in this cap. Maybe they can just look forward for this positive information.
Yeah, they should receive. I think the second round of selections will probably take place sometime in July, possibly, maybe early August, and they'll receive some additional selections for the different companies.
Okay, that's good to know. Thanks for sharing this information. Thanks. Yeah.
Okay.
Yeah.
Michelle?
Yeah.
Sure. Thank you, Joe. So I was informed that many people had questions relating to the L visa and the H1B, how to get on the L or off the L and onto H or off the H and onto
Correct.
L. Essentially, there's an overlapping 6-year limit with both of these visas. The important thing to remember, I don't know if anybody was on the last call, but we discussed the dual intent between visas. The L and the H do have dual intent. So they're both good visas if you're getting on board the green card train. They set you up for having a good perm filed for you, then an I-140, and then eventually a 485. With that being said, though, there are limitations to the L visa. One of the limitations is you have to work on the approved L, the petitioned L that you were approved for. So this limits people. You can't really transfer to another country because the nature of the L visa itself is an intra-company transfer. It's a company and another company that are related and are essentially sending over an employee because of a specialized knowledge or managerial expertise that individual holds. The H1B is more broad, and you can change employers on the H1B. But again, to get off of L and get on H, you still have to go through CAP, even though you do share that same time limit. And I guess I would need some particular questions to kind of explain it more, which we're always happy to answer on Q&A. But essentially, the L visa is a specialized visa pursuant to the nature of your position. The H1B is specialized knowledge in a certain position. It's not tied to any particular company.
So I can go into a little bit more detail about the L1, Michelle. And
thank you.
The one reason a lot of individuals from India would like to pursue the L visa, especially the L1A for managerial and executives, is because typically there isn't a retrogression for those available visas. But in order to be eligible for an L1A, you'd have to be an executive or manager, working for the affiliate abroad and coming to the United States to hold an executive or managerial position. So individuals who have been working abroad, maybe in a specialized knowledge position or in a managerial position, can always apply to be an L1A in the United States. And it's a rigorous process, and the applications are reviewed in detail. But the nice thing about it is that once you're in the United States as an executive or manager performing those type of functions, you can petition for your I-140 and I-45, and you completely bypass the perm labor certification stage. So it's a faster way of getting a green card for the executive and managerial capacity individuals, but there are, high bars you need to go through and meet to qualify for it. The L1B specialized knowledge, they're scrutinized at the consulates especially. So they're more difficult to go through and obtain for someone that's typically in a staffing type position. But if you're working for a multinational organization, there's a specific process or software that's specialized to that entity, then it's easier to obtain those L1B specialized knowledge cases. But when someone is in the United States on an L1 to change over to an H1B, you would have to be selected in the lottery, and you'd have to be in status through October 1st when the H1 would become effective.
Okay, thanks for that information, Michelle and Joe. Yeah. And few people are questioning about B1 visa as well, Michelle. B1 to H1B, H1B, H1 to B1 when they lose their job, when there is a layoff.
Yeah, Usha, that's the layoffs have been a serious issue for a lot of individuals within the IT sector, more so for the larger organizations and the direct placements versus staffing. Most of our clients within the staffing industry are able to find a new position for the employees versus someone who may be working at maybe Dell or Microsoft or Apple, who when the person gets laid off, they really don't have any type of recourse to try to find another position with a different entity. In the case where an H1 is laid off, they're given a period of 60 days to find a new employer to file an H1 with, or change status to a different category. So they give them a 60-day grace period, which can be used by the H1 individuals. And if you file another H1 within that 60-day window, you can actually start working for the new employer once Homeland Security receives your application and acknowledges receipt of the application. So portability does apply when you're going from an H1 to an H1 when you're in that 60-day grace window. And if you're going to possibly maybe apply for an F1 visa within the 60-day window, you'll be fine. You'll be in status. Back in the day, the law basically said that once your status. I'm sorry, Swapna? Oh, I'm sorry. Yeah. So it's okay. So back in the day, before the 60-day grace period, once a person fell out of status, Homeland Security had the discretion to go through and basically tell them to leave the country. And even if they filed for another H1B, if it was after they received their last paycheck, they would technically have to leave. So the 60-day grace period allows for someone to stay in the country and also go through and file for another visa while still maintaining status. Michelle, do you have anything to add?
Yeah, I think I would just mention, and as we discussed last time too, the B visa is not a dual intent visa. So it's not ideal for you to be on the B visa because you're telling the United States that you don't have the intent to eventually stay. It only has a non-immigrant intent. So getting on B1, as everybody mentioned, is usually a fallback, or it's how to get into the United States to begin with, because the B1 is for international visitors who wish to come to the United States for business reasons. And then, as mentioned on the side, these business reasons are conferences, conventions, meetings, estate settlements, contract negotiations, and other things that qualify for the visa. The main drawback to the B1 as a medium by which to obtain the H1B is the short period of stay. You're not here for, really long time. It's usually 6 months are the increments that you have on the B visa. And again, that intent issue. And like, as Joe said, typically you're not going to fall your backup plan. It wouldn't be an additional visa or a different visa changing status. It would just be your grace period.
That's good explanation, Michelle. Go ahead. Yeah.
And then the next slide, I believe we went over it. Joe mentioned that if you arrive in the United States with a certain intent and later change that intent, you should submit an application to change status before your stay expires. That means in the time you have, in the time you're permitted to be in the United States, apply for a change of status while you're in the United States and before you expire. That way, you wouldn't have to go to any consulate to get your visa. You would just kind of automatically change status. Another thing that really was emphasized by Joe is waiting for your approval. You have to maintain your status. So don't assume your status is approved as changed until you have physical approval in your email or in your hand. And then my example to this was if you arrive as a tourist and wish to become a student, wait until you have authorization as a student before you begin school. And then the requirements for changing status is generally, you may apply to change your non-immigrant status if you are lawfully admitted into the U.S. with a non-immigrant visa, your non-immigrant status remains valid, and you have not violated the conditions of your status, and you have not committed any crimes that would make you ineligible. A lot of times, the most common crime, quote unquote, I've seen for people on a non-immigrant visa, like the H1B, is drinking offenses, either drinking and driving or impaired driving, or those are taken very, very seriously by the United States, and many times really jeopardize your stay and your, approved petition.
Yeah, Michelle, that is a good point because, due to some changes in policy, and sure most individuals don't know this, but if there is a drinking offense, if someone leaves the United States, the consulate can revoke the visa, not allowing the person to come back into the country. So if anyone on the call or anyone's friends that are on the call, if they do have a drinking offense, I wouldn't recommend leaving the United States because you may have issues in trying to re-enter the United States. And typically local law enforcement's database is accessible to Homeland Security for the individuals at the Customs and Border Protection, CBP officers. They can ask you questions about charges or convictions. And if that happens, your ability to enter the United States could be impeded.
Oh, that's a good to know, Joseph. Yeah. So how long they have to be staying out of the country? I mean, if they should not go for the stamping, is there anything, is there time limit or anything, is there? How long they will take it serious? Assuming that he crime 5 years back, still it will be considered as a default, or is it okay after a couple of years?
They'd have to file for a waiver
Oh,
to come back
okay.
in. Yeah, so they take it very seriously. Their position is that someone with a drinking problem, it's a medical problem, but it could go through and harm citizens of the United States and, residents that are residing here. So they take it seriously. We're in Michigan, obviously, and Canada's our border. If someone does have a drinking offense, they won't allow you into Canada, and vice versa. People coming from Canada with drinking offenses, Customs and Border Protection won't allow them to come in.
Mm-hmm.
So,
thanks for sharing that important information. Thanks. Yeah.
I know that Evan had a question about compelling circumstances, EADs. If you want, we can answer the questions as they come up, Usha.
Yeah, definitely. Yes. Yeah. When we come to the question answer session, then we can just answer the questions. A few more people. Yeah.
Okay.
Sure. Yeah. You want to continue, Michelle, for the next slide?
Sure. The next slide was about the B1 because there were some questions about that too. This was just a fun fact, but you don't need to apply to change your non-immigrant status if you're admitted in the United States for business reasons for the B1 category and wish to remain for pleasure until your stay or before your stay expires. That's why it always says B1/B2. And then when I do not need to change status, this is probably not going to apply to very many people, but you do not need to apply to change your non-immigrant status if you wish to attend school in the United States and you are the spouse or child of someone who is lawfully admitted in the United States in any of the following non-immigrant visa categories: the A visa, the E visa, the G visa, the H, the I, the J, the L, the F, the M. Dependents are usually safe from, they never need to change status because their status is dependent on someone else. And then individuals who may not apply for a change of non-immigrant status, you cannot change your non-immigrant status if you're admitted in the United States by a visa waiver program, by a D non-immigrant visa, by a C non-immigrant visa, in transit through the United States without a visa, the fiance of a U.S. citizen or a dependent of a fiance, it's called the K non-immigrant visa, or an informant on terrorism or organized crime, which is the S non-immigrant visa, which was exciting for me to look up because I never really see some of these. And then the next portion of the discussion is just open questions that everybody's welcome to ask.
Yeah. I think Evan asked few questions. Can we just go ahead with that first? Even he asked for, I'm on H1B visa, can layoff be compelling circumstance to apply for the compelling circumstance EAD after the layoff, and when is a good time to apply for the compelling circumstance EAD in the 60 days grace period?
You want to apply for the that EAD as quickly as possible, once they encounter the layoffs. But basically the compelling circumstance EAD can be issued for up to a 1-year period. However, it doesn't allow the individual to maintain a non-immigrant status. So if during this 1-year period, they found an employer willing to hire them once again on H1B status, they'd have to leave the United States to apply for the visa abroad and then come back in. But, there's certain circumstances other than just leaving or just being laid off from your employer. You need to have some other reason. A layoff or a termination isn't necessarily compelling. They look to situations where there's like a serious illness in the family, or the individual is ill, or maybe the employer is retaliating against the employee because the employee files a complaint against the employer. So there's certain government agencies that may be involved, such as, for a wage and hour division investigation. So the employee is staying there to go through and assist with that. They're going to look to see if, there could be substantial harm to the applicant, or maybe to a U.S. employer that wants to go through and hire them because they need a certain individual with specialized skills within a certain occupation. So there's more to it, but typically they'll get the EAD for up to 1 year, but it's not a non-immigrant status. So if they want to go through and do a change of status afterwards, they'll probably have to go through and leave the United States to get it done there.
Okay. Even that, hopefully it answers your questions. And on following, he has one more question too. What happened to the approved H4 EAD for the spouse? Will that be invalid with the end of the grace period as well? And do we need to apply for both spouse separate EADs for H1NE and H4 dependent?
So the H4s are always dependent upon the H1Bs. So technically the H1 will still be in status of that 60-day grace period because it can file a change of employer. But once the grace period's over, the H4 status is in jeopardy, as is the H1B, unless a new application is filed for both individuals. If during that 60-day grace period, this H1 employee that was laid off finds a new H1B employer and files a new application before the 60-day grace period, the H4 spouse will still be in status. The spouse doesn't have to file an extension of her H4 status, but the validity period on her I-94, that's going to control her lawful status. If her husband gets an H1 approved for another 3 years, whatever the expiration date is on her I-94 card, that's going to govern. It will not be his 3-year H1B approval that he gets with a new employer. So eventually the spouse will either have to file for an H4 extension or leave the country and get an H4 stamp in her passport and then come back in. What I would recommend doing to avoid confusion, have the spouse file with her husband, or he can file with his wife, depending on whoever the H1B is, but have the H4 file the extension with the H1B. And if they use premium processing, they'll both get them approved quickly. And they can also request their EADs at that point in time also, if they choose to do so.
Okay, thanks for detailed explanation. Hopefully it helps Ivan to sort it out his problem. Next is Pramila has a question. If both parents have H1B, within bracket I-140 approved, but green card is not current yet. Question is, can the H4 dependent kids apply for H4 EAD once they turn 16 years so that they can do internships or join a job?
The EADs are for the spouses, not for the children. So the children wouldn't be able to go through and apply.
Yeah, okay. So the H4 EAD will come to spouse, spouses alone, spouse alone.
Yes.
For the kids, they have to wait for their own AOS EAD or something like that, right?
Mm-hmm.
Yeah.
Correct.
Okay. Yeah. Thanks. Pamela, does it answer your question? If there is any other questions, can you, from anyone else, put it in the chat?
You hear me?
Yeah, Pramila.
Yeah, actually, I checked with my employer and they told me that they would be eligible for applying for H4 EAD, but I was like, I checked in many forums and everyone told me that they are not eligible. So I was kind of, I don't know, like what to believe. And also that, the government website, it says that 16 to 18 years, they can apply for H4 EAD. It's under the archive section somewhere. So I wasn't sure, like, what's the latest on that?
It's for the spouses, Pramila.
Okay, only the spouses are eligible. Okay.
Yeah, the EADs can be issued for different categories depending on the category, but for the H4s, it's for the spouses.
Okay, yeah, thank you.
Yeah, there's also one question we're getting a lot of, basically frequently from some of our clients that weren't selected in the lottery, Usha. It's basically another way of filing for an H1B is if some individuals that are on H1 status are working for exempt organizations like a hospital or a school, when they're working for the exempt organization, these individuals can take a part-time H1B or a concurrent H1B with a for-profit organization that normally they'd have to be counted towards the cap. But since they're already on H1 status, they can actually go through and work, part-time or work a second job with a H1B employer that would be subject to the cap. So for some of the people that may not be selected or that may be working for a nonprofit organization that's H1B cap exempt, there's ways of actually taking a part-time employment also and still be able to work for a profit organization.
Okay. After completing OPT, not in OPT, right? When they are in other citizens.
When they're on an H1B status. So
H1B status, yeah.
Exactly. So we have clients that are professors at universities. So they're teaching computer science, and they're working on H1 statuses for the universities. However, they want to earn extra income, and they want to work part-time for maybe a staffing organization or a direct hire who is subject to the cap. Well, since they're working on an H1 that's exempt, they can do a concurrent part-time H1B to work for another organization that would normally have to file under the cap.
Okay. And I have one more question, follow-up question on that, Joe. See, this concurrent H1B, both the work location has to be within the area of around 75 miles or something radius, or it can be different place, because someone was mentioning in some other call stating that they have to be in the same location because they should be able to justify to USCS later. They can accommodate both the jobs. Is it so, or that's okay? It is not necessary.
It depends on the job. If someone's working at a university and then they're taking a concurrent H1B and working in a different state, if they can manage it, that's fine. But most of the time, it's difficult to go through and do that unless maybe the person's working on the weekends, then they can go to a different state. But usually, when you're filing an H1B and you're working at a specific location, if you're going to file a concurrent H1B, common sense or normally you'd have to work in the same geographical area.
Okay. Yeah. Okay, that's good to know. Okay, same geographical area within this. Yeah. So we should we should keep the main H1B LCA location as a main part, first as a first one, and then can go for the concurrent with the same location.
Yeah, I mean, yeah, typically when clients are going for concurrent H1Bs, they're usually working remotely. So remotely, the person most likely is going to work at the same area where his home is located, unless there's another client within the same geographical area. But the LCAs dictate where a person works. So if someone's working within a certain county and then they're taking a concurrent H1B and working 70 miles away, well, they would just file, the concurrent H1B with the new location 70 miles away.
Okay, thank you, Joseph. Thank you, Joe, on that. Yeah. Next, one more follow-up question from Ivan. What happened to the approved H4 EAD for the spouse? Will that be invalid with the end of grace period as well? Do we need to apply for both spouse separate EADs for H1 and H4 dependent?
I think we addressed it. The H4 will still remain valid through the 60-day grace period. And if at the end of the 60-day grace period, if he hasn't filed for another H1 or another non-immigrant category, then both statuses would pretty much end at that time.
Okay. Yeah. Thanks, Joe. The next question is from Madhukar Prasad. Can H1B can H1B with I-140 approved can move to F1 if you are already enrolled in the course at the university? That is number one. And the second question, can it change to F2 if the spouse is already in F1? Can we move back to H1B once we get the offer?
Okay. So that question depends on the individual's country of birth, because with individuals from India, there's a retrogression of the visas. So by filing an I-140 petition isn't always clear evidence of someone's immigrant intent, because the visa may not be available for 10 or 11 years. So can you go through and change status back to F1? Technically you can, because you're not eligible to file the adjustment of status. So the fact that you filed an I-140 petition and it's been approved isn't 100% evidence of your immigrant intent. So is it possible to do so? Yes. Well, could they question you when you're entering and exiting the United States? Yes. But is it possible to do? Yeah, it is possible. It's just a little bit risky if you're traveling internationally. So the second part of the question is, can I change to F2 if the spouse is already on F1? Yeah, you can do that. It's going to be the same situation, but you can do it. The one thing that I advise is always be truthful in the application. So if you're changing over to the F2, the change of status, they ask if you filed an immigrant petition or has one been filed on your behalf. Tell them the truth. Never lie on an application. Give them a copy of the approval notice. They'll see that the priority date is probably not 10 years away. So immigrant intent may or may not be present, because we really don't know what we're going to do 5 or 10 years from now. So if the priority date is current, that's something different. But if the priority date is not current, then you shouldn't have a problem in being able to change over. And I believe this third question was, can we move back to H1 once we get the offer? Yeah, you can always go back to an H1B status from an F1 or an F2.
So all these things changing from status to status, will it be affect when they're going for the green card down the line, maybe after a few years when they go for it? Will it affect? Will there be any question raised at the time of filing 485? No. Okay.
No, as long as they maintain a lawful status, as long as the people are legally in the United States and maintaining their status, it doesn't matter if you change from different categories to the other, as long as you're doing so and the information that you provide is truthful.
Okay, that's good to know. Yeah, that is glad. Yeah. Thanks, Joe. And one more next question from Pramila. If and when the kid's H4 age of 21 years is the only option to convert to F1 for continuing further education here in the US, how likely is it the kid to get the F1 visa approved, since F1 is a non-immigration visa and the entire family is here in visa with approved immigration petition, I-140? Wouldn't that could be considered as no ties back to home country and visa be denied? Necessary, right?
It's a good question. There were some changes recently with the Child Status Protection Act and how it's interpreted by Homeland Security. In the past, and the way the Child Status Protection Act works is that you get to recapture any time, or the time that your I-140 immigrant petition is pending, you're able to go through and add that time to your 21st birthday. So basically to prolong it. So if someone is whose parents filed an I-140 petition, the I-140 has been pending for 11 months. That 11-month pending period for the I-140 can be used to reduce the child's, age at the time the I-45 is filed or eligible for being filed. So if, say the I-140 is pending for a year, the child is 21 and 1 year of age, 21 and 1 month of age at the time the family can file the I-45s, the Child Status Protection Act would allow that child to file the application, because technically their age isn't 21 years and 1 month. It's actually 20 years and 1 month, because the I-140 was pending for 1 year. So that can be used to the benefit of the child and the family to file for their I-45. So aging out is a serious issue. And in the past, we always had to use the final action date of the visa bulletin. Now, basically, what's been said is that if you're eligible to file the I-45, whether it's the final action date or the dates for filing chart, you're going to be protected, and you'll basically avoid aging out for the children. It was allowed for a period of time to go through and file based on the dates for filing, and the applications based on the dates for filing chart wouldn't secure your place in line, or wouldn't freeze your date of birth for the 21st birthday issue. Now, they basically said if you're eligible to file the I-45 with your family, they'll freeze your date of birth, and you can use the, any time that the I-140 has been pending to reduce your age from the 21 years. So there's been changes, and in this situation, I'm not sure how old the children are, but assuming that they've already aged out, and we don't know how long the I-140 petition was pending, it's, they're going to be a situation where their option would be to file for the F1s. And
so when you said we can add the time for the 140, like whenever that's pending, would that also include the perm process, like the entire?
No, Pramila, it's a good question. It's only the time that the I-140 is pending. So what we've told our clients, if you're filing your I-140 petition and you have children that are, around 15 to 16 years of age or even younger, we recommend that you don't use premium processing. You let it go as long as possible, because anytime that the I-140 is pending, you can basically reduce your child's birth by that number of days.
Okay.
So it's better to have the I-140 pending for a long time versus getting a quick approval in 15 days under premium processing.
Okay. Yeah. My daughter, like she's 15 years, and both myself and my husband, we have separate, I-140s. So
Okay.
we can use whichever is longer, right? In that case, kind of give some edge. Okay. Yeah.
How long have your I-140s been pending?
It's approved, but I think it took like 6 months.
Okay.
Yeah.
So basically what you would do in your child's situation, you would basically take her date of birth and, reduce it by 6 months.
Okay.
So if she's 15 right now, she'd be 14 and a half for, immigration purposes.
Okay. And you're saying that we can use date of filing as well?
Yes. Yeah. So if you're eligible to file in her dates of filing, it'll preserve her age at that point in time.
Okay. Oh, that's good to know.
Yeah. Because a few years back when everything was current back in 2020, people were filing, but it was, you could file into the dates for filing chart, but the dates for filing wouldn't freeze your children's date of birth. As a result, some of the kids that did file the I-45s turned 21, and Child Status Protection Act wouldn't protect them any longer. So they weren't eligible for the 45s any longer because they aged out. But they've changed that now.
Okay. Yeah, that's good. And the other question was about suppose like even if we did everything and still the kid ages out, like at that point is the only option for them to continue further studies is to convert onto an F1 visa, right?
Correct.
Yeah.
Yeah.
And wouldn't that be like because if all of us are here and they know that we are on immigration status, but that conversion, would that pose any issue?
If I was in that situation, I'd have my child remain in the United States. I would not have my child go through and leave, because if she does, or he, leaves the United States, gets a visa stamp and tries to come back in, they could, at the consulate, say that the person's an intending immigrant because the person doesn't have sufficient ties back to their home country to go through and return there after they complete their studies. So in a situation like that, I would definitely not have someone on F1 status leave. I'd have them stay in the United States until they get to the H1 status. Once they're on the H1 status, they'll be fine. But on the student status, once again, there's a non-immigrant intent component. And if the child can't prove that they're going to return to, in your case, maybe India, Pramila, then they may not give, your daughter the visa at the consulate if she decides to leave. Definitely have the family members stay in the United States that are on those statuses.
Right, but have to convert at one point from H4 to F1 here in the US, right? For her to continue with her education.
That'll be fine, because technically she doesn't have an immigrant intent, because she's not eligible for I-45 filing. So she's aged out, so she'll be on her own.
Got it. Yeah, makes sense. Thank you so much.
You're welcome.
Thanks, Joe. Thanks, Pramila. Our next question from Sridhar. I was out of status for 2 weeks in COVID 2020 during COVID time. Will it be a problem in stamping?
When he was out of status
for 2 weeks, that means from he changed his task. He changed his from one employer to other employer.
Okay.
At that time, there was a 2 weeks in between. Out of status. Sridhar, can you just explain more information?
Yeah. So when we,
Thanks,
during that time, during the COVID time, I was terminated from the company X to X. So I'm just moving to Cogent. So while processing, we filed LCA little bit late because my side also got delayed. So it took 2 weeks. The 60 days grace period was over, and I took another 1 or 2 weeks to process the visa. So, my last visa date was, let's say, June 2nd, and the next visa I got it from June 15th. So there was a 10 days gap without status. I cannot move out of the country. Also, I cannot apply any of the visa during that time.
Because during the COVID time, it was a peak period, June time. Yeah.
So, in that case, there is a provision when you're doing your adjustment of status, 245K, which basically will excuse an absence of up to 180 days. So in that case, Sridhar, you would still be fine.
Okay.
And also during the COVID time, people couldn't travel and leave the country. Homeland Security was aware of that. So they have the ability to excuse a late filing using non-proton, which is basically a provision that asks for the officers to excuse a late filing for various reasons. And that can happen. So it's in the officer's discretion. The fact that your H1 was approved with the new I-94 card, you're in good shape.
Okay, perfect. Sounds good. Yeah. Thank you very much, sir.
You're welcome.
Thanks for clarifying that. And next question from Ivan. Is it the same question? I'm not sure. It is Ivan. I'm on the H1B I-140 approved single earner. Child is US citizen and studying in school. With layoff is not sufficient enough. The reason for compelling circumstance to continue his education and staying in the US. I know.
For the compelling circumstances, there are outlined reasons. So substantial harm to the applicant is one. What you can basically indicate is substantial harm would be to the US citizen child. because the U.S. citizen child is attending school. So that can be a reason. But you also have to be aware that compelling circumstance EAD, eventually it's going to expire. Typically they're issued for about a year. And when they do expire, you're most likely to have to go through and leave the United States to get a new visa stamp because you're not in a non-immigrant status any longer. So that's, just keep that in mind, Evan, when you're seeking to go through and possibly consider that as an option.
Yeah. Thanks, Joe. Next question, I'll just, it's from Madhukar. It's a good question, actually. Thanks, Madhukar. How is a grace period days calculator if the company is giving severance period pay and 2 months payroll and the company has not revoked H1B petition? How much grace period I will have before the change of status?
Okay. It's a good question. And severance pay doesn't provide evidence that someone's maintaining their status. It's basically, the last day that you're working at an employee of the organization. If the organization does not notify Homeland Security that the application or that the individual has been terminated, the employer is obligated to go through and pay. So you can make an argument in that situation that the company is obligated to pay and that you're still employed. It would be more of a violation in a wage and hour issue. But if the employer follows proper protocol and notifies the employer of the termination, and they're going to give a severance pay, in this case, it says the company is giving severance pay and 2 months payroll. So if it's a 2-month severance period, it's going to go to the last day that the person was working. And I'm assuming the company is going to go through and terminate the H1B. At that point in time, there's 60 days there after the termination is done. If an employer doesn't terminate the H1B, then the employer is obligated to go through and pay. So assuming person's last day is June 1st, Homeland Security is notified, they get a letter from the employer saying that they're terminated. Even if the company gives 2 months of severance, that's fine, but the 60-day grace period will start June 1st and it will go 60 days. It doesn't go 60 days after the severance period expires.
Okay. Thanks, Joe. Thank you. The next question is from Swapna. My daughter is 19 years old and soon she will be 20. She will be going to undergrad from this August. So when is a good time to apply for F1? And my I-140 is approved 1 year back.
Michelle, you want to answer that?
Sorry, sure, of course. I'm just pulling up the question. Sorry, so I'm on 2 devices because I had shared the PowerPoint on one and my phone on the other one.
Okay. I can take it, Michelle. So let's see, your daughter is 19 years old and soon be 20 and going to undergrad in August. F1s can take a long time to go through a process because she'll be going from an H4, I'm assuming, to an F1. 539 applications are what's going to be utilized. So I would say, filing it probably at least 6 to 9 months in advance would probably be best. It's not going to make a difference if she's going to be on the H4 or the F1 at that point in time. So once she reaches, her 20th birthday, a couple months later, I would probably say go through it and file that application. Because the one thing about a change of status, and we didn't discuss this earlier, is that if you file a change of status and then you leave the United States, the change of status application is abandoned, which basically means that you'll have to apply for that visa at the consulate abroad. You can't just come back in on an H4 and then assume that the F1 change of status will still process. It doesn't work that way. So whenever there's a change of status and you file it in the United States and then you leave, then you abandon that change of status application. So in this situation, I don't know if Swapna, if you have travel plans, planning on leaving the country or anything, but if you do, then I would highly recommend, coordinate the time that you file the F1 with your travel. Take care of your travel first and then file the F1 afterwards, because, if you file it right now and then you leave at the end of the summer for a vacation, the F1 change of status will be useless. They'll basically deny that application.
I also have another question. I have another daughter who will be completing 18 years this July.
Okay.
Next year, July. She will be completing 18. And she's US citizen. So if I start the process, a citizenship process, I don't know the process, but I'm just asking. If I start the process, would it be any help for me and my daughter to apply for the citizenship and for her to change any status change rather than being on the F1?
It's not going to help your daughter, but I mean, it could help you and your spouse in doing so. But you know, your daughter's gonna have to be at least 21 years of age, so you're gonna have to wait about 3 years. So once your daughter turns 21, then she would be eligible to petition for yourself and your husband, because you know, U.S. citizens who are 21 years of age or older can apply for their parents. But it's not, I mean, she can apply for your daughter, but it's, I mean, you know, the wait times for brothers and sisters is quite long.
So my question, isn't it the age for children to apply for their parents is 19 years? Is it 21 years?
It's 21.
Oh, okay. Okay, thank you.
Mhm.
Also, I just wanted to add in the processing time for any kind of change of status filed through a 539, as Joe indicated. It depends on what service center it'll go to. Some service centers are faster than others. There's a processing time window, but just for perspective, and I just checked it while, you know, we were answering questions. You know, the Nebraska Service Center is taking almost 14 months to adjudicate a 539 request to change status to F or M student category, whereas, you know, the Vermont Service Center is taking 5 months. So it's always something to also just put into perspective with what service center is going to be adjudicating the petition as well. It's also just food for thought, because that's almost, you know, a year difference. So with that being said, whenever there is a case-by-case situation, you guys are always welcome to email me. I know that Usha has my contact info, and you guys can always email me directly. We can get you some answers to questions that you have, especially if they're nuanced. So in the event of the, you know, the individual who has the daughter who's going to college, you can just email me your information, and then I can check which service center, you know, your petition would be filed at, and then I can give you the processing time for that service center, just for, you know, perspective for you. And that's all I wanted to say.
Yeah, so Swapna, for your daughter, it depends on where you're located. Michelle made a great point, and I didn't think of that, but some 539s are taking over a year, you know, 14 months. So you may want to go through and consider filing her H4 to F1 sooner than later. And also during that time period, if you do travel, that change of status application will be abandoned. So I don't know if you're planning any trips overseas, but if you are, you know, you may want to go through and consider filing for her F1 at that point in time if you're traveling abroad, because, you know, if she goes to the consulate overseas, she'll be immediately issued the visa, and she can come back in on the F status versus trying to file it in the United States.
Thank you. No plans of traveling to India, but I live in Pennsylvania.
By any chance, like if after 6 days I travel to India, like could you provide like either transfer or like I-129 filing from India itself? If we have a project, just wanted to check.
I'm sorry, I couldn't understand your question. I couldn't hear you very well.
Voice was breaking. Can you just put it in the chat, please?
Filing the H1 transfer from India, does going to provide that service or no? raise that right now. Just
I can't understand you, Evan. I'm sorry. Can you type it in the chat?
Is H1 transfer possible from Cogent while I'm in India?
I'm just checking if there's a possibility Cogent can find project like while I'm in India, because right now I'm on my grace period, so just checking the options. Or do I have to stay in US while I do transfers?
His question is, I think H1B transfer is possible from Cogent while I'm in India.
Correct.
So we can you
Okay, so sometimes we have situations where our clients are on an H1 status and they're finally from one H1 company to a second H1 company, and then they need to go through and leave the United States. Since it's a change of employer and an extension of their status, they can leave the United States, come back in, continue working for their existing H1B employer, and once the approval goes through, they can go through and transfer to the other employer, or they can come back in while the application is pending and show the officer the receipt notice and start working for Cogent again. It's a little bit riskier that way, but is it possible? Yes. But in a situation like that, we always, if you're going to go through and you're on H1 status, file for an extension with the same employer and leave and come back, no problem. But when you're going to a different employer, it gets a little bit riskier that way. So it's always good to come back on an approved H1B, but technically you can leave while you have an H1 pending, if you're on an H1 status and maintaining that status at the time of filing.
does it answer your question, Ivan?
Yes.
Okay, thank you.
So someone sent in a question to Usha saying that I'm on H4 visa status and want to enroll for a master's program in August. If I transfer visas from H4 to F1 in the United States and will travel to India, will it impact status or not? If you're on H4 and you're going to an F1 and you leave while the change of status application is pending, it'll abandon the change of status application. So the only way you'll be able to come back in on an F1 to study will be going to the consulate, getting the visa stamp, and then coming back into the US. The better way or better option would be to stay on the H4, travel, come back in, and then file for the F1 at that point in time.
Does this answer your question? Thanks a lot. I think he's clear about it, right? Yeah. Okay. Thank you very much. Yeah. Do you have any questions? Can you wind up this call? If anyone switches work location to fully being remote while staying in the same MSA, do we need to file H1B amendment?
No.
No.
If it's the same position and your home is close to the location listed in the LCA, you don't need to go through and file an amendment, but you do have to repost the LCA at the new work location. So you'd have to post it if you're working from home, in your home, 2 conspicuous locations for 10 consecutive business days, and then send the posted copies back over to the HR.
Thanks, Joe. Thanks for clarification on that. Thank you. Michelle, you want to add anything, or can you just wind up this call, or do you want to add anything, Michelle? Please.
Sorry, I was unmuting. No, I don't have anything to add.
Okay, thank you.
Like I said, I'm happy to answer anything, anybody, any questions that arise at any time. You guys are always welcome to reach out.
Thanks a lot for everyone to join this call. Thanks, Joe. Thanks for your valuable response for each and every question. And we have shared a link here in this chat box. You can just save this, and then if there is any question, we can just upload it over there. You can save it. Definitely will get the help of Michelle and Joe. Will get back to you on your questions.
Definitely. Thank you, Usha. Thanks, Terry.
Thanks, Joe. Thanks,
Thank you.
Michelle.
Thank you.
Thanks.